The grand marble columns that supported the roof of the federal courthouse stretched imposingly across the vast, crowded hearing room, imparting an air of solemnity and authority that could not be ignored. Their imposing presence seemed to reinforce the significance of the proceedings taking place within those stately walls, while at the same time lending an almost intimidating grandeur to the entire setting. At the center of this formal arena sat Judge Richard Leon, a man of considerable experience and stature. He adjusted his glasses carefully, a habitual gesture that betrayed a moment of quiet focus, before turning his attention to the notes meticulously laid out before him. These notes encompassed the complex details of the case, data points, legal precedents, and procedural nuances that he would need to keep in mind as he prepared to preside over what had quickly become one of the most eagerly awaited and highly scrutinized legal battles of the year. Meanwhile, at the designated podium, Representative Jasmine Crockett approached with a quiet dignity and unwavering confidence that was evident even to the most casual observer. Her posture was composed, her expression calm but resolute. She faced a formidable team of attorneys representing Technological Giants Corporation, one of the world's largest and most influential technology conglomerates, who stood accused of a serious breach of privacy. The allegations against the corporation were grave, systematically collecting vast quantities of Americans' personal data and then selling it without obtaining transparent consent or providing proper disclosure to the public. The courtroom trembled with an intense atmosphere. An almost palpable tension hung in the air. Law students sat beside journalists and concerned members of the public, occupying every available seat and even standing along the walls, eager to witness this crucial legal confrontation unfold. Cameras were discreetly positioned around the room, silently recording every moment for later dissemination, as reporters and spectators alike waited with bated breath for the first words to be spoken. Crockett began her opening statement, setting forth her case with clarity and conviction. But before she could fully articulate her initial argument, Judge Leon raised a hand sharply to interrupt. His voice, crisp and commanding, filled the room as he addressed the Congresswoman directly. "Congresswoman Crockett," he said, "your argument appears to contradict established legal precedent, as upheld by at least 3 different circuit courts. Are you seriously requesting this court to disregard decades of settled law that has become the foundation of our legal system?" A hush descended over the entire courtroom. Terrified glances exchanged among the law clerks, who recognized the significance of the moment. The opposing attorneys, standing with confident smirks on their faces, seemed convinced that the judge, known for his unwavering adherence to legal rigor, was about to dismantle Crockett's case in mere minutes. However, what transpired next defied all expectations. Crockett paused briefly, a moment of contemplative silence, then responded with a carefully crafted argument, so thoroughly researched and legally precise that even seasoned courtroom observers later referred to her reply as a masterstroke of advocacy under intense pressure. Her words displayed not only mastery of the law, but also an exceptional ability to think on her feet and articulate complex legal concepts with clarity and authority. The judge, Richard Leon, was an 81-year-old giant of the federal judiciary, an individual whose career spanned decades of high-profile and often controversial cases. Appointed by President George W. Bush in the early years of the 21st century, Judge Leon had presided over numerous landmark rulings that shaped the contours of privacy law, national security, and corporate responsibility. His legal opinions had left a lasting mark on the development of legal standards that continued to reverberate through the judiciary. Before ascending to the bench, Leon's career encompassed roles both as a prosecutor and a defense attorney, giving him a nuanced understanding of the intricacies from multiple angles. During his time in public service, he served as Deputy Assistant Attorney General, and as a special counsel to various congressional committees, where he investigated major political scandals that captured national attention. This breadth of experience endowed him with a profound insight into the inner workings of government, law enforcement, and the legislative process. Known for his meticulous preparation, Judge Leyen often posed pointed and incisive questions during proceedings, a characteristic that made clear he had studied his cases in unprecedented detail, often more thoroughly than the lawyers who argued before him. His courtroom was a place where intellectual rigor reigned, strictly fair but demanding in its expectation of clarity, precision, and substance. Standing opposite him was Jasmine Crockett, then 45 years old, representing Texas's 30th congressional district. Despite being only in her third term as a member of Congress, Crockett had already earned the reputation as one of Washington's most incisive and sharp-minded legal thinkers. More than most of her colleagues, she continued to practice law in a selective and deliberate manner, often taking on high-stakes cases that aligned directly with her legislative priorities. Her background was rooted in civil rights law and public defense, fields that demanded resilience, integrity, and a deep commitment to justice. She was an accomplished graduate of Rhodes College and the University of Houston Law Center, credentials that underscored her mastery of law and dedication to public service. Her presence in this courtroom exemplified her reputation, not merely as a legislator, but as a formidable advocate with the skill to navigate complex legal arguments under the most intense scrutiny, all in pursuit of justice and accountability. She had spent years representing clients in complex legal battles that reached the highest levels of the judicial system, presenting cases before both state Supreme Courts and federal appellate courts. Her specialty was constitutional law, with particular expertise in issues concerning individual privacy rights and the limits of government interference. This dual experience, acting as both an advocate in court and an analyst of legislative intent, earned her a unique authority and credibility in the halls of Congress, where she was known for her ability to connect the complexities of law with tangible, real-world implications for ordinary people. In the courtroom, she always kept in mind the original purpose behind the statutes she was defending. She understood the legislative intent deeply, which allowed her to advocate more convincingly. The case that ultimately united these two formidable legal minds, a courtroom veteran and a legislator turned lawyer, centered around a prominent tech giant known as Tech Giant Corporation. This powerful company found itself embroiled in controversy after allegations surfaced that it had engaged in the illegal collection and sale of highly sensitive personal data belonging to millions of American citizens. Despite having paid a relatively modest fine to the Federal Trade Commission, the settlement reached with regulators was widely viewed as superficial, offering little real accountability or effective safeguards for consumers. It was seen as a slap on the wrist rather than a meaningful reprimand, leaving many affected individuals feeling exposed and vulnerable. Crockett, who represented a collective of citizens impacted by the company's actions, volunteered her services on a pro bono basis. She challenged the settlement vehemently, arguing that it did not suffice to protect consumers' privacy rights or ensure fair treatment. Her goal was to push for comprehensive legal remedies that would hold the company truly accountable. Standing against such a giant of industry, Crockett faced an elite cadre of lawyers assembled by Tech Giant, composed of specialists from 3 of the country's leading law firms. At the forefront of this legal team was William Bradford, whose reputation for fierce litigation and meticulous legal strategy was well known. Rumors buzzed through the legal circles that Bradford's hourly fees exceeded $2,000, a testament to both his skill and the stakes involved. The case carried astronomical implications, possibly involving billions of dollars, and the future business model of Tech Giant itself hung precariously in the balance. For the millions of Americans whose personal data was at risk, this litigation represented perhaps their only genuine chance for justice and redress. Beyond this, the outcome could set an influential precedent in the technology industry at large, shaping how companies handle consumer data and enforce privacy standards in the digital age. For Judge Leyen, presiding over the proceedings, The case posed complex constitutional questions, delving into issues at the intersection of cutting-edge technology and fundamental rights that had been established long before the dawn of the digital era. For Crockett, the case was intensely personal. Having dedicated her legislative career to strengthening privacy protections, she now sought to enforce those rights through the courtroom, effectively testing whether the legal system was equipped to shield ordinary citizens from the excesses of powerful corporations. The current hearing focused on tech giants' motion to dismiss the case before it reached trial. If the court granted this motion, millions of Americans would lose their legal avenue for accountability. Their grievances would be effectively silenced. Conversely, if Crockett succeeded, the company could face significant public scrutiny, with its questionable practices exposed and subjected to legal and societal review. Unbeknownst to the corporate legal team, and even to the presiding judge, Crockett had spent countless months preparing for this pivotal moment. She anticipated the objections her opponents might raise, meticulously studying centuries of case law and legal precedent to craft an argument that would not only surmount immediate challenges, but also have the potential to reshape privacy law in the United States. Her preparation was so thorough that she believed her legal strategy could fundamentally influence future judgments in similar cases. The courtroom gallery was filled with a palpable sense of anticipation. The opposing legal team from tech giant had spent the morning plotting their defenses, relying on technical legal arguments about standing and jurisdiction, points designed to block the case's progression, hoping to make the case seem legally unviable. Bradford, confident and composed, addressed the court with authority. "Your Honor," he began, "this case should indeed be dismissed because the plaintiffs have failed to establish the necessary standing under Article 3 of the Constitution. The Supreme Court has repeatedly reaffirmed that merely violating statutes without demonstrating concrete harm is insufficient grounds for a federal lawsuit." Judge Leon listened attentively, occasionally glancing at the thick stack of legal briefs before him, weighing the arguments as the proceedings unfolded. As Bradford concluded his presentation, the courtroom's atmosphere grew noticeably more serious. The judge, with keen attention, leaned slightly forward and directed pointed questions, clearly indicating that he was engaging with the argument with utmost seriousness and careful scrutiny. Turning to Bradford directly, the judge asked, "Mr. Bradford, you have extensively referenced the TransUnion case in your motion. How do you respond to the plaintiff's assertion that the data involved in this case goes beyond just credit information, implying that the scope of data collected exceeds what is traditionally considered relevant for credit reporting?" At this, Bradford responded with a confident smile, a gesture that suggested he felt certain about his position. He explained, "Your Honor, while it's true that the nature of the data in this case differs from typical credit information, the underlying principle remains consistent. The key issue here is whether the plaintiffs can demonstrate that they suffered concrete harm caused by the collection of this data, rather than merely pointing to a statutory violation or technical breach. In our view, they have failed to do so in this instance." His words echoed a belief that the core legal question was whether the alleged data collection could be classified as causing tangible injury, something that, in his view, was not achieved here. As the courtroom listened carefully, Crockett approached her podium to oppose the motion. She carried a modest but carefully organized stack of notes, embodying a sense of calm authority and focused attention. Her posture and demeanor conveyed her readiness to engage with the arguments presented. Acknowledging the precedent cited by the defense, Crockett shifted her focus to a critical issue that would become a turning point in her entire argument. She addressed the court with measured confidence, stating, "Your Honor, while my opponents correctly refer to the TransUnion case, they overlook a crucial distinction highlighted by Justice Kavanaugh in the majority opinion. On page 9 of that decision, the court explicitly recognized that intangible harms can constitute concrete injuries, even when no visible physical or tangible effect appears." Judge Leon raised an eyebrow, signaling his interest and perhaps some curiosity about her perspective. He prompted her to continue, saying, Please go on, Congresswoman Crockett. Crockett proceeded to elaborate, emphasizing that the court's recognition of certain harms as concrete was rooted in long-standing legal principles. She explained, the court's acknowledgement of privacy violations as concrete harms has deep historical roots, tracing back to Blackstone's commentaries on the common law and the traditions that shaped our Constitution. Unauthorized collection and dissemination of private information, such as personal data that individuals expect to remain confidential, are recognized as concrete harms that demand legal remedy. These principles date back to 18th century English law, which understood that the wrongful disclosure of private matters constitutes a tangible injury deserving redress. Bradford shifted uncomfortably at this point, realizing that Crockett's historical context was a detail that had not been extensively emphasized in her original briefs. His discomfort was visible, but Judge Leon leaned forward with a thoughtful expression, clearly intrigued by the line of reasoning. He remarked, "Interesting. But how does this argument manage to overcome precedents set by the Ninth Circuit Court of Appeals, which Bradford cited earlier?" Crockett responded to this challenge with clarity and precision. "Your Honor, I am not requesting that we disregard the existing precedent. Instead, I argue that the precedent does not apply to our specific case for 3 distinct reasons," she stated firmly. She held up a finger to emphasize each point. First, the cases from the Ninth Circuit involve situations where data was collected, but, crucially, was neither used nor shared with third parties. In contrast, here we have documented evidence that a major technology company sold data to no fewer than 147 third-party entities without obtaining proper consent from the individuals involved. She raised her second finger. Second, the precedents from the Ninth Circuit predate the landmark case of Spokio v. Robbins, as clarified in the TransUnion decision. Justice Thomas explicitly acknowledged that disclosing personal data to third parties constitutes a concrete harm, an injury that must be recognized under the law. Finally, Crockett lifted her third finger. Third, there exists an acknowledged but unresolved split among federal circuits regarding this issue, as noted in footnote 4 of the TransUnion ruling. While the Ninth Circuit maintains a restrictive view, other circuits, the Third, Seventh, and Second, recognize unauthorized dissemination of personal information as a tangible harm that warrants legal remedy. At this point, Bradford frantically flipped through the TransUnion decision, clearly eager to verify her claims. His expressions revealed a mix of surprise and growing curiosity as he absorbed her detailed explanation. Crockett, sensing the opportunity, continued smoothly, citing additional case law to reinforce her argument. Furthermore, according to the precedent set in Thompson v. Data Corporation, non-financial data transfers, such as the sharing of personal or private information without valid consent, also constitute an actionable harm. The sharing of such data, even if not financial in nature, infringes upon individuals' right to privacy and, therefore, should be recognized as a concrete injury deserving of redress. As Crockett articulated each point systematically, the courtroom's mood gradually shifted from routine hearing to something resembling an advanced seminar on privacy law. The tension grew subtly but unmistakably, with law students in attendance feverishly taking notes, and even the clerk assisting Judge Leon, captivated by the depth and precision of the legal exchanges taking place. What had initially appeared to be a simple opposition to a motion had transformed into a high-level legal discourse, illuminating complex questions about data privacy, existing legal standards, and the evolving interpretation of what constitutes a tangible injury under the law. The atmosphere within the courtroom underwent a remarkable transformation as the judge's questions shifted from formal inquiry to a more collaborative and engaged dialogue. It was evident that his genuine interest in the legal principles Crockett was passionately advocating had begun to influence his manner of questioning, signaling a move away from mere procedural demand towards a deeper exploration of the substantive issues at hand. The initial tone of a routine motion hearing gradually gave way to an environment reminiscent of an intense, intellectually stimulating seminar, in which each participant and observer was eager to grasp the subtleties of Crocketts' legal reasoning and arguments. Every eye in the room was now focused sharply on her, attentively listening as she articulated complex points with clarity and confidence. The courtroom's energy had changed dramatically. The seriousness of the proceedings, combined with the stakes involved, created an almost electric atmosphere. Professors, law students, and legal practitioners in the gallery sat on the edge of their seats, their notebooks open and pens poised, eager to capture each legal nuance and subtle distinction Crockett drew upon. It was unmistakable that what might have started as a standard legal motion was rapidly escalating into a high-stakes intellectual contest, where sharp reasoning and precise legal interpretation were crucial. The judge, previously sitting with a somewhat skeptical expression, now leaned slightly forward, his gaze focused intently on Crockett. His pen moved rhythmically, jotting down notes as he posed a critical question, revealing both his curiosity and a desire to understand her argument more deeply. He asked Crockett whether her theory of standing was one that the court would recognize as valid in this context, adding an inquiry about its applicability to cases involving encryption data transferred to third parties. In response, Crockett did not hesitate for a moment. She explained confidently, "Your Honor, this precise issue was directly addressed by the United States Court of Appeals for the District of Columbia Circuit in the case of Johnson v. Medical Soft." She elaborated that the court's ruling clarified that although technical safeguards might mitigate the risk of harm, they could not completely eliminate the damages resulting from unauthorized transfers, especially in instances where the recipient maintained encryption keys, such as the case involving data transfers by over 83 big technology companies. As Crockett continued to speak, a subtle shift flickered across the judge's face. It was as though he was impressed by her mastery of a relatively obscure case law, which added weight and credibility to her arguments. Bradford, noticing this shift, sensed that the momentum was slipping away from his position. In a bid to regain control of the situation, he tried to intervene, beginning his statement with a tone of authority. "Your Honor, I must point out that—" But before he could proceed, Judge Leon cut him off sharply. His voice was firm and clear. "Mr. Bradford, are you suggesting that this court lacks the authority to interpret existing statutes in the context of new and evolving technologies? That notion appears inconsistent, especially considering your position in the data stream case before Judge Williams last year." Bradford, caught off guard by this pointed inquiry, hesitated, realizing he would need to recalibrate his argument quickly. He responded cautiously, "Your Honor, the contexts are different." Yet the judge was quick to challenge him further. "Are they? In both cases, the statutes under consideration were enacted before the advent of current technological capabilities, and in this very data stream case, you argued for a broad and expansive interpretation to support your client's interests, whereas here, you advocate for a narrower, more constrained interpretation." He paused for effect, his gaze intense as he pressed, "Principal application, or simply what benefits your client most?" The courtroom, which had been silent except for the exchanges of arguments, now murmured softly as the judge's words cut to the core of the issue. It was rare for Judge Leon to highlight inconsistencies with such candor, and his directness caused Bradford's face to redden slightly as he searched for a convincing explanation. Crockett, meanwhile, maintained her composure and seized the opportunity, addressing the court with calm authority and professional poise. "Your Honor," she began, "the Supreme Court has long recognized that courts must adapt their statutory interpretations and constitutional principles to keep pace with technological advancements. Justice Roberts, in the case of Carpenter v. United States, emphasized that the privacy protections guaranteed by the Constitution must persist and remain effective despite technological progress. Statutory protections against data collection and transfer by private entities should be understood and applied with the same fidelity to the core principles of individual privacy and due process that they have historically embodied. Courts are obliged to interpret these legal frameworks in a manner that ensures their continued relevance and effectiveness in the face of constant innovation. The gallery seemed to collectively lean forward, sensing the strength of her argument. Her words resonated with a deep understanding of both the legal precedents and the fundamental principles underlying privacy rights in the digital age. Crocketts' position was not merely about technicalities. It was about the enduring values of justice and the necessity for the law to evolve thoughtfully, ensuring that vital protections remain effective regardless of how rapidly technology advances. The judge listened carefully, his expression thoughtful, recognizing the persuasive force of her comprehensive and well-grounded reasoning. During the proceedings, it was not uncommon for the law clerks present in the courtroom to exchange quiet whispers, their hushed voices reflecting a mixture of curiosity and admiration. They discussed how convincingly she had dismantled Bradford's argument concerning the separation of powers, demonstrating an extraordinary mastery over legal reasoning and rhetoric. As the hearing stretched far beyond its scheduled duration, initially slated for only 30 minutes, it was now approaching the 2-hour mark. This extension underscored the significance of the case and the intensity with which all parties and observers engaged with the proceedings. At a crucial juncture, Judge Leyen leaned forward slightly on his bench, his expression marked by a deliberate and thoughtful gaze. He posed a single question that would come to hold decisive weight in the case. It was a question that would cut straight to the core of the legal debate. "Congresswoman Crockett," he asked, his tone measured but penetrating, "even if all your allegations are taken at face value, the fundamental question remains. What is your strongest response to the argument that no concrete harm has been demonstrated, and therefore there is no justification for federal intervention in this matter?" A profound silence immediately fell across the courtroom. The atmosphere became densely focused, every observer experiencing heightened attention. This inquiry was no ordinary question. It was a carefully calibrated probe designed to test the very foundations of the plaintiff's claims. The judge's tone, calm yet genuinely open to persuasion, indicated a willingness to consider arguments that might challenge current assumptions. Those present recognized that this was a pivotal moment, a rare opportunity for the plaintiff to articulate a compelling response to the core issue. Crockett, feeling the weight of the moment, adjusted her posture slightly. She recognized that this was a strategic opening and leaned into it confidently. Her expression was composed, her voice calm, but filled with purpose as she began her reply. Her words would later be cited in numerous law review articles, reflecting their clarity and significance. She started, "Your Honor, the concrete harm involved in this case is neither speculative nor purely theoretical. It is deeply embedded in both our constitutional framework and the long-standing principles of common law." She paused briefly, allowing her assertion to resonate before continuing with conviction. The framers of the Bill of Rights understood that privacy protections should extend beyond mere physical intrusions into our personal space. The essence of liberty includes control over one's own information, a principle that remains as vital today as it was centuries ago. The Fourth Amendment does not specify that tangible damage is a prerequisite for legal protection. Instead, it guards against unwarranted searches and seizures, including the intrusions upon our privacy, regardless of whether those intrusions result in immediate, observable harm. Her reasoning was clear. The violation itself, the invasion of private space and personal data, qualified as significant harm. The judge nodded subtly, signaling his understanding and cautious agreement with her line of argument. It was evident that Crockett's articulation was resonating with him. He was following her logic carefully. Encouraged, she continued, adopting an even more measured yet confident tone. In the realm of common law, she pointed out, harms are recognized even when no direct financial loss is involved. Actions such as trespass, an unlawful entry onto another's land, or invasion of privacy, interfering with an individual's reasonable expectation of seclusion, are actionable on principle alone, without the need to demonstrate specific damages originating from those acts. Now, she pressed on, consider the position of this large technology corporation, which seeks to persuade the court that, unless there is a financial loss or a clearly defined negative consequence, Americans have no legal recourse when their most intimate personal data, such as medical searches, location information, voice recordings made when the device was supposed to be inactive, or private messages that are encrypted and meant to be confidential, is collected and sold to hundreds of third parties without their consent. This assertion, she argued, fundamentally misunderstands the nature of privacy harm and the principles that underpin our legal protections. Reaching into her case file, she retrieved a sealed envelope, carefully handling it to avoid any trace of contamination or breach. With a respectful gesture toward the court, she held it up and stated, "With the court's permission, I submit this sealed exhibit as evidence demonstrating the tangible and concrete nature of the harm involved in this case." Her voice was steady, yet imbued with clarity and authority. Judge Leon gestured toward his clerk, who promptly approached to receive the envelope. The atmosphere was charged with anticipation as the clerk asked politely, "What does this exhibit contain, Counselor?" Rochelle Crockett explained confidently, "It contains actual data that the defendant, the technology giant, collected and subsequently sold from 5 named plaintiffs in this suit. Specific data, not generalized metadata. There are detailed medical search histories, precise location tracking information, voice recordings captured when the app was inactive, and private messages encrypted during transmission. All of this data was obtained legally through discovery in a related legal proceeding under a strict protective order that allowed its use exclusively within that context." She emphasized that this evidence demonstrated real, ongoing harms that could not be dismissed as mere abstractions or hypothetical situations. Bradford, listening intently, was quick to object, raising a procedural concern. "Your Honor," he interrupted, "this material was not included in the original complaint. Introducing such new factual claims during a motion to dismiss is improper because it could unfairly prejudice the defendant by changing the factual landscape at this stage of the proceedings." The judge, however, maintained a calm demeanor. He regarded Bradford with a steady gaze and responded, "A motion to dismiss requires that all factual allegations made by the plaintiff be taken as true, and the court must assess whether those allegations, if proven, would entitle the plaintiff to relief. If the evidence introduced by the plaintiff supports the core factual claims, then its consideration becomes appropriate even at this stage. It is not about adding new claims, but about evaluating the validity of the existing allegations with the support of available evidence." Crockett, not deterred, explained further, "Your Honor, the data I've just described was obtained through discovery in the related case, pursuant to a protective order explicitly permitting its use in this legal process. This naturally makes it relevant to the current motion, because it directly reflects the nature and extent of the harm suffered by these individuals." She paused briefly, allowing her explanation to register with the court, confident that her argument was sound and aligned with procedural rules. After a moment's reflection, Judge Leon nodded, signaling that he understood and was inclined to consider the evidence in the context of the case. "I will carefully re-express and expand upon this narrative, transforming it into a more detailed and fluid account that preserves the original meaning, enriches the description, and ensures the language remains clear and polished for easy comprehension and delivery. The final version will be approximately 1.5 to 2 times longer than the original text, providing a comprehensive, nuanced account of the courtroom scene, the arguments, and the legal intricacies involved. I intend to revisit this case thoroughly in the designated chambers before proceeding further. Please, continue with your argument, counselor, and I will listen attentively. Seamlessly, Crockett shifted her position, prepared to make her next point. Addressing the judge with respect, she emphasized that the core of the defense's stance hinges on the belief that corporations are entitled to gather and profit from some of the most personal and sensitive information of American citizens without obtaining truly meaningful consent. Furthermore, she pointed out that these companies often sell this data on a broad, unregulated scale, all the while asserting that they can avoid accountability because the harm inflicted by such practices is classified as intangible or non-quantifiable from a legal perspective. This line of reasoning, she argued, is fundamentally flawed both legally and ethically. It strikes at the very foundation of privacy rights, rights that have been an integral part of American legal and moral tradition since the nation's founding. She made a gesture towards the gallery filled with spectators, indicating the importance of the issue at hand. Next, she urged the court to consider just how superficial the consent process often is, asking an average American to scroll through and click "I agree" on a lengthy, often complicated, 46-page terms of service agreement does not constitute truly informed or meaningful consent. Such a brief, mechanized act cannot be equated with an earnest approval or understanding of how personal data will be used and shared. She pointed out that claims suggesting anonymization techniques are foolproof are misleading. According to recent studies, nearly 80% of Americans can be uniquely identified using only 3 pieces of data, specifically their zip code, date of birth, and gender. This revelation sent a ripple through the courtroom, capturing the attention of everyone present. Behind her, reporters with notebooks and cameras worked furiously, capturing her citations and arguments with haste, knowing that her statements could have far-reaching implications. Crockett produced internal emails from executives at major technology companies, revealing their own internal acknowledgement that modest claims of anonymization are often insufficient or deceptive. These documents demonstrated that the companies themselves recognize the limitations of their efforts to protect user identities. Meanwhile, Bradford, the opposing counsel, frantically scribbled notes, attempting to craft a response to arguments he had not anticipated, evidence that threatened to undermine his entire position. Crockett pressed on, articulating that the harm caused by these data practices is concrete and multifaceted. First, there is a violation of individual autonomy, since personal data is taken and used without explicit permission or informed consent. Second, there is the ongoing risk of harm because this data circulates among numerous third parties, increasing the possibility of misuse and further breaches. Third, the risks intensify when sensitive data is aggregated, exposing individuals to potential exploitation, from health information being exploited to financial vulnerabilities being targeted, creating a fertile ground for malicious actors. Judge Leyen listened carefully, nodding with evident attentiveness, making notes as Crockett outlined each point with clarity and conviction. Bradford, sensing the weight of her argument, raised an objection once more, citing procedural issues, arguing that her statements were not relevant or that they overstepped certain legal boundaries. Crockett responded confidently, addressing his objections and reinforcing her position. She pointed to paragraph 78 of their complaint, which detailed specific allegations of targeted fraudulent communications. These declarations served as supporting evidence for her claims, reinforcing the existing allegations rather than adding new assertions, she explained. The judge took a moment to review the complaint, flipping through the pages thoughtfully. After a brief pause, she looked up and nodded, acknowledging Crockett's point. "You are correct, Mr. Bradford," she said calmly, overruling his objection. The courtroom's atmosphere shifted as Crockett sensed her arguments gaining traction and the groundwork laid for a stronger legal framework. Undeterred, Crockett moved forward to emphasize that statutes designed to safeguard privacy are not just technical or procedural rules. They embody fundamental protections recognized by Congress. She stated that Congress explicitly acknowledges that violations of privacy rights cause real, tangible harm, even if such harm isn't always straightforward to measure in monetary terms. The rights to have control over one's personal information have long been considered core civil liberties, and courts are obligated to enforce them when violated. Her words resonated through the chamber as she underscored the importance of these protections. The judge posed a precise and pointed question, reflecting her careful consideration. "Counselor, doesn't this approach risk relaxing the requirements for establishing standing? If merely violating statutory rights grants standing, are we not blurring the lines between different legal inquiries?" Crockett responded with clarity and conviction. She explained that, contrary to that concern, the Supreme Court's standards require that statutory rights be closely tied to harms traditionally recognized at common law. She elaborated that the core harms, such as intrusion upon seclusion, the unwarranted public disclosure of private facts, and the appropriation of a person's name or likeness, are well-established, long-standing legal concepts. These traditional harms have been recognized by courts for centuries and are now reflected in modern statutes, which serve as their contemporary equivalents. The link between statutory protections and these familiar legal harms is direct and undeniable, she emphasized. The court's atmosphere noticeably shifted. Once skeptical, Judge Lyon's expression grew more engaged, her demeanor indicating that she was considering the implications of Crockett's reasoning carefully. Observers in the courtroom immediately sensed a transformation. Momentum was turning in favor of the prosecution. Crockett had expertly reframed the discussion from dry procedural technicalities to profound, substantive legal doctrines, demonstrating how technological advances intersect with enduring principles of privacy law. In doing so, she illustrated convincingly that the protections established centuries ago remain relevant and vital today, especially as new challenges arise from the rapid evolution of digital technology. Her argument underscored that privacy rights are not merely abstract or archaic rules. They are essential safeguards designed to adapt and withstand the tests of modern times, ensuring that individuals retain meaningful control over their personal information in an increasingly interconnected world. Crockett paused thoughtfully, her gaze sweeping across the courtroom with careful intent, ensuring that every listener remained fully engaged with her words. She then addressed the court with a calm yet compelling tone, highlighting a crucial point that often escapes notice in cases of this nature. "There is one final aspect I wish to emphasize regarding the question of concrete harm," she began, her voice steady and deliberate. "In this matter, Your Honor, the defendant, the technology giant, asserts that under the current legal framework, Americans do not have a reasonable expectation of privacy unless they directly suffer specific, identifiable consequences as a result of data breaches or misuse." She paused briefly, allowing her words to settle among the attentive listeners. However, this assertion is fundamentally flawed and overlooks the centuries of judicial reasoning that have consistently recognized the inherent importance and value of personal privacy. Crockett's words resonated deeply within the courtroom, which filled quickly with an understanding of her underlying argument. She continued to elaborate, explaining that in the context of the digital age, the widespread and systematic exploitation of individual personal data represents a novel yet very real form of injury, a kind of harm that previous generations' courts had not explicitly addressed, but which nonetheless demands recognition. Historically, she pointed out, courts have demonstrated remarkable adaptability when confronting emerging threats to individual rights. She provided examples from the past, noting how issues like industrial pollution and broadcast defamation, initially lacking specific legal precedents, ultimately became recognized injuries because the nature of harm had evolved beyond traditional boundaries. In her view, society now faces a similar challenge concerning digital privacy and data security. Essentially, what was once unrecognized as an injury is increasingly becoming acknowledged as such, as technology introduces new avenues for intrusive misconduct. Her argument did not go unnoticed. It seemed to strike a chord throughout the courtroom. Each person present, from eager law students to seasoned reporters, listened intently, following every measured point with rapt attention. Judge Leyen's pen moved smoothly across the paper, meticulously capturing both the substance of her reasoning and the underlying significance of her insights. When Crockett concluded her presentation and gathered her notes, the atmosphere in the courtroom shifted into a profound silence, filled with a quiet acknowledgement of the gravity of her words. What was at stake in this case went far beyond mere legal statutes or procedural standing. It was a fundamental question about whether the current legal system truly recognizes and safeguards the right to privacy in an era when technological advances have made intrusive actions far more accessible, pervasive, and profitable. Her concluding words, "Thank you, Your Honor," hung in the air, inviting reflection. A stillness fell upon the room afterward, a rare and almost reverent silence that underscored the impact of her argument. Even Bradford, the opposing counsel, appeared momentarily speechless, as if momentarily caught in the shock of her reasoning. The students in the courtroom whispered quietly among themselves, admiration evident in their whispers. Reporters at their desks furiously typed, capturing every detail of her presentation, while court clerks nodded quietly in appreciation of her ability to synthesize complex issues so effectively. Judge Leyen, seated confidently at his bench, leaned back slightly, his face marked by a look of contemplation. For the first time that morning, a faint smile appeared on his lips, a subtle acknowledgement of the formidable intellectual effort Crockett had brought to the case. It was a rare gesture, indicative of his recognition of her mastery. Bradford rose to respond, his earlier confidence noticeably shaken. His words came out cautiously, tinged with a measure of uncertainty. "Your Honor," he began, "Congresswoman Crockett's argument is undeniably thorough, but it predominantly relies on historical and theoretical perspectives that are open to debate." He added that the courts, including the Ninth Circuit and other circuits, had already established clear, well-defined standards concerning standing, standards that, in his view, should not be dismissed lightly or without due consideration. His voice held a steady tone, but an undercurrent of hesitation betrayed his doubt. The courtroom listened intently, aware that this was a pivotal moment, the point at which the legal strength of the defense's position would be scrutinized most closely against the meticulous groundwork laid by Crockett. Judge Leyen interjected promptly, his interest sharply piqued. He looked directly at Bradford and posed a question that cut to the core of the matter. "Mr. Bradford, I am particularly interested in hearing how you reconcile your argument with the Second Circuit's Thompson decision, which Congresswoman Crockett cited extensively during her presentation. Could you clarify how your reasoning aligns, or perhaps conflicts, with that precedent?" The room, filled with anticipation, waited carefully for Bradford's reply, recognizing that the discourse was now entering its most critical phase. This case bears a striking resemblance to a previously examined legal scenario, especially when it comes to issues surrounding the unauthorized dissemination or sharing of data that does not have a financial nature or component. As the proceedings unfolded, Bradford's grip on his podium tightened noticeably, revealing his mounting apprehension and effort to maintain composure under pressure. Meanwhile, he swiftly, almost instinctively, flipped through his notes in a rapid series of motions, desperately scanning for any references or precedents related to Thompson that might serve to reinforce his argument or tilt the case in his favor. Yet, it became immediately evident to everyone in the courtroom that Crockett's preparation had been meticulous and thorough. She had anticipated this line of questioning, this very confrontation, long before they had entered court that day. Her calmness indicated a deep familiarity with the case history and the legal nuances it entailed.
Your Honor,
Bradford began, continuing from the point of the original Thompson decision. While that case presented persuasive arguments on certain matters, it is inherently distinguishable from the current case due to the specific nature of the data involved and the particular financial contexts that were addressed there. The scope and the details involved in the Thompson ruling pertain to different categories of data, and the financial implications explored in that instance do not match the context of the technology sector or the operations of large tech corporations that are central to this case. Because of this, applying the principles and conclusions from the Thompson decision directly to our situation would not be appropriate or legally justified. Throughout this exchange, Crocketts' gaze remained fixed on the judge with unwavering steadiness, exhibiting neither doubt nor distraction. With measured calmness and a respectful tone, she responded, addressing the court directly.
Your Honor, the Second Circuit Court explicitly addressed the issue of non-financial data transfers in its rulings. In particular, on page 27 of that decision, Judge Sullivan's opinion explicitly stated that the specific type of data at issue is of less importance than the fact that there was an unauthorized transfer to third parties. Such a transfer, in itself, constitutes a form of harm and violation. This perspective directly correlates with the evidence we have presented, where sensitive private information, such as medical records, location data, and personal communications, was shared with hundreds of different entities without the individual's consent or approval. She allowed a brief pause after her statement, giving the court and all present an opportunity for her words to resonate and settle within their minds. The weight of her words was not theoretical or hypothetical. Rather, it was backed by documented, ongoing, and critically significant harm. An almost imperceptible murmur rippled through the courtroom as the implications of her statement began to sink in. Even among some members of the gallery, who had arrived without an in-depth knowledge of privacy law or the technical intricacies of data protection, there was a palpable understanding of the seriousness and importance of her point. Judge Lyon, observing the proceedings with focused attentiveness, quickly jotted down notes with a pen moving swiftly across his notepad. After finishing his note-taking, he nodded slightly in Bradford's direction and posed a pointed question. Counsel, how does your interpretation account for this explicit acknowledgement in the Thompson case? His tone was deliberate, emphasizing the significance of the judicial recognition. Redford, Bradford's counterpart in this legal debate, hesitated for a moment. The confident demeanor he had previously displayed appeared to waver as he searched for a suitable response. After a brief pause, he replied, Your Honor, while the Second Circuit did acknowledge those aspects in the Thompson case, it was within a specific framework of statutory interpretation that was tailored to those particular circumstances. This framework differs from the current case we are examining. Judge Lyon's tone grew sharper, more deliberate, cutting through any ambiguity. Is the legal principle itself different in this context, Mr. Bradford? Or are we simply dealing with different specifics within a similar principle? He paused, allowing his words to settle before continuing. You argued at length in your initial submissions that data transfers under analogous circumstances should be interpreted broadly, yet now you are advocating for a narrow application here. Are you applying the law consistently or merely trying to serve the interests of your client? A tense silence descended upon the courtroom once more. The atmosphere became almost electric with anticipation, the tension almost tangible. Bradford's eyes darted toward his colleagues, who were frantically rifling through their briefs and notes, seeking some form of line of argument or case law to support him. Even the most junior clerks sensed that this line of questioning was extraordinary and potentially decisive. The judge, Lyon, was not only scrutinizing the logical coherence of Bradford's argument,
but also whether the defense's approach was consistent and principled across different cases. His aggressive questioning indicated that Crockett's strategic move had successfully shifted the momentum of the courtroom, placing Bradford on the defensive. Sensing an important opening, Crockett stepped forward slightly, her confidence renewed. She addressed the court directly. "Your Honor, the United States Supreme Court has repeatedly held that when statutory laws encounter rapidly evolving technological developments that the framers of the law could not have foreseen, then the courts must interpret and apply these laws in a manner that adapts to the new context, all while adhering to fundamental principles of justice and fairness." She paused briefly, letting her words emphasize the importance of legal adaptability and judicial responsibility, especially when navigating the complex intersection of law and technology. The ruling made by Judge Leyen in this case vividly exemplifies the fundamental principle that legal protections are not merely theoretical constructs, but are meant to serve as real safeguards in practice. This principle has traditionally been associated with government surveillance, where laws are designed to prevent unwarranted intrusions into individuals' privacy and personal freedoms. However, in recent times, there has been a significant shift in how these protections are being applied, extending beyond state actors to encompass private corporations and commercial entities that handle personal data. This expansion reflects a broader understanding that the same principles of privacy and rights should be upheld regardless of who is collecting or processing the information. When private companies gather, monetize, and disseminate personal data without obtaining clear, informed consent from the individuals involved, this situation creates tangible and immediate harm. Such harm is not merely hypothetical or speculative. It is real and must be recognized by the courts as a violation of rights. This shift underscores the crucial idea that the law must acknowledge the harmful consequences that arise from negligent or reckless data practices, especially when those practices infringe upon individual autonomy. Judge Leyen listened carefully, his nodding indicating his keen engagement with the legal arguments being presented. As the proceedings continued, his tone shifted from being combative or dismissive to more inquisitive and thoughtful. He began asking questions aimed at exploring how the legal framework introduced by Crockett could be applied to hypothetical scenarios, which is a common practice in judicial deliberations to clarify and test legal theories. For example, he inquired whether a person's data, even when anonymized, could still cause harm if it could be re-identified through data aggregation. This question exemplifies the evolving complexity of privacy law in the digital age, where simple notions of anonymity no longer guarantee safety. In response, Crockett affirmed without hesitation that such scenarios indeed involve concrete harm, emphasizing the robustness of her legal framework. She pointed out that even data labeled as anonymized by the company's internal documentation could be re-identified with minimal additional information, a fact that the company's own internal documents openly acknowledged. Specifically, the chief data officer admitted that claims of anonymization might hold true in a technical sense, but are essentially meaningless in practical terms because re-identification is easily achievable. The aggregation and combination of various sensitive pieces of information, such as locations, health records, and private communications, create risks that extend beyond immediate financial loss. These risks include the potential for targeted exploitation, identity theft, and unwarranted surveillance, all of which represent serious and actionable harms recognized by courts over many centuries. The courtroom atmosphere grew more animated this time, responding audibly to Crockett's arguments. Reporters, who had been documenting every word with rapid keystrokes, paused momentarily in surprise or recognition of the significance. Some members of the audience, seated on public benches, leaned in closer and quietly exchanged whispers, indicating their interest and understanding of the legal points at stake. Meanwhile, Bradford, representing the opposing side, furiously scribbled notes. His intent was clear. He was trying to anticipate Crockett's next move, or perhaps to prepare objections. However, Crockett had already considered and accounted for each possible challenge, demonstrating her preparedness and mastery of the material. Turning toward the judge, Crockett's voice remained steady, firm, yet respectful, an essential trait in courtroom advocacy. She proceeded to outline what she considered three primary forms of concrete harm that her case meticulously identified. The first type of harm she described was the violation of personal autonomy. In other words, when someone's data is taken or used without obtaining genuine, meaningful consent from the individual who owns that data.
The second harm concerned the ongoing exposure of personal information, data that, after collection, continues to circulate among hundreds of different entities, each of which may have varying levels of security and different intentions regarding that information. This persistent circulation increases the likelihood of misuse or breaches. The third form of harm involved the increased risk posed by aggregating sensitive information. When data, from health histories to financial details, is combined, it creates a potent profile that can be exploited, leading to targeted attacks, identity theft, or intrusive surveillance. Crockett highlighted that courts have long recognized these kinds of harms as concrete and legally significant, rooted in a long-standing tradition of protecting individual rights through centuries of legal reasoning and jurisprudence. Bradford quickly objected once more, raising concerns that Crockett's claims relied on new factual assertions not originally included in the initial complaint. He argued that these additional facts might be prejudicial or outside the scope of the original charges. Crockett, maintaining her composure, responded carefully, clarifying that her argument was based strictly on the allegations already laid out in paragraph 78 of the complaint, which explicitly involved targeted fraudulent communications stemming from data collected by the defendant. She explained that the evidence she was presenting simply supported these existing claims, without introducing any new or extraneous allegations. Her evidence aimed to substantiate what was already alleged rather than expand the scope of the case in any unauthorized manner. The judge, after briefly reviewing the complaint and examining the supporting documents, made a decisive ruling. He indicated that the objection was overruled, affirming that the complaint indeed contained the allegations in question and that the evidence offered was appropriate for consideration within the case's context. As a result, Crockett nodded politely in acknowledgement of the court's decision and proceeded to develop her argument further, confident that her legal position was sound and supported by the available documentation. This legal exchange exemplifies the rigorous process by which courts scrutinize claims related to privacy and data security, ensuring that every argument is thoroughly examined and only well-founded evidence is accepted. It underscores the principle that violations of privacy, especially those involving concrete, tangible harms, are deserving of judicial recognition and remedy, principles that continue to evolve as technological and social landscapes change. Your Honor, the fundamental purpose of the law must serve as a guiding principle when it comes to interpreting rights and protections. In the legislative framework, Congress deliberately intended privacy rights to serve as a shield against various forms of intrusion, not only those that are tangible and readily observable, but also those that are subtle, intangible, and harder to detect. A narrowly confined interpretation, which dismisses or minimizes these less obvious harms, would be directly contradictory to the clear intentions behind the legislation. Such an approach would undermine the long-standing legal recognition of privacy as a core, fundamental interest that deserves protection. Historically, courts have demonstrated a remarkable ability to adapt their understanding and judgments in response to new and emerging threats or harms, whether this has manifested in environmental law, defamation cases, or other areas that continuously evolve alongside society's technological and social advancements. In today's world, digital privacy has become the newest boundary of concern, representing the latest frontier where rights are tested and redefined. Judging by the courtroom's atmosphere, Judge Leon's attention was fixated on her words. His pen moved deliberately across the paper, faithfully capturing the intricacies and nuances of her argument. He then posed another pointed question, seeking clarification and challenge. He asked, "Counselor,
Does this approach not risk eroding the very concept of standing by allowing any statutory violation to automatically confer the right to sue? If every breach of law guarantees access to the courts, where do we establish a fair boundary? The attorney, Crockett, responded with a calm, confident smile. She acknowledged the concern, but explained that the concept of standing remains rooted in the idea of harm. Specifically, the type of harm traditionally acknowledged by common law. She clarified that modern statutes build upon these traditional notions, codifying protections against harms that, although occurring within new technological contexts, are fundamentally similar to those recognized before the digital age. She pointed out that concepts such as intrusion upon seclusion, disclosure of private facts, and the appropriation of one's personal identity serve as contemporary equivalents of earlier privacy violations. The connection between past and present is direct, well-documented, and legally accepted. At this point, the courtroom had become fully engaged. Students seated in the gallery were furiously scribbling notes. Reporters typing at rapid speed captured every word, and the legal team representing the defense looked increasingly strained under the weight of the arguments presented. Judge Leyen's questions evolved from initial challenge to a more profound exploration, probing how Crockett's legal theorization might be applied practically across different hypothetical scenarios and various technological landscapes. This displayed a rare, genuine judicial interest, an engagement that signaled her ideas held significant bearing on both the theoretical and practical understanding of privacy law in the digital era. Crockett paused briefly, ensuring her points resonated clearly with her audience, and then continued with final remarks. Her voice remained steady and unwavering as she said, "Your Honor, I would like to present one last consideration." She emphasized that the defense hired by large technology corporations relies on a troubling assumption that privacy only becomes meaningful when an individual suffers measurable financial or tangible losses. This view runs counter to the core principles embedded both in our history and the constitutional fabric of the nation. Privacy, she argued, is inherently valuable and deserving of protection simply because it is an essential aspect of personal autonomy and dignity. She pointed out that the wrongful collection, sale, and dissemination of personal data constitute clear harms in themselves, regardless of whether any additional consequences, such as financial loss, are immediately apparent. In the evolution of law, courts have continually recognized and addressed new forms of injury as society advances, and the realm of digital privacy is no different. The gallery remained silent, fully attentive, absorbing every word of her presentation. Even Bradford's junior associates, often preoccupied with their own tasks, now displayed signs of engagement, quietly acknowledging the exceptional clarity and intellectual rigor of Crockett's argument. The judge, taking notes with a look that conveyed respect and recognition, appeared to be thoughtfully contemplating her points. Crockett finished organizing her papers and sat back, aware that the question facing this court was whether our legal system can and should evolve to sufficiently protect privacy rights amid the rapid development of digital technology. Her final words were simply, "Thank you, Your Honor." Several seconds of tense silence followed before the courtroom settled into a quiet, contemplative state. Bradford rose to his feet, approaching the podium, but his confidence appeared noticeably diminished compared to the beginning of the hearing. His prepared rebuttal, which earlier seemed well-structured and persuasive, now seemed inadequate to counter Crockett's comprehensive and meticulously reasoned presentation. He hesitated briefly, then proceeded, but his response lacked the strength and clarity needed to challenge her well-founded arguments effectively. He made an effort to respond, drawing upon precedents and technical interpretations to support his position. However, Judge Leyen's sharp and insightful questions swiftly uncovered the reality that the balance of persuasive power had clearly and decisively shifted in favor of the plaintiff. Each attempt to cite legal precedents or technical reasoning was carefully examined through pointed questions from the judge, questions that went beyond mere formalities, and challenged whether those precedents truly applied to the specific evidence that Crockett had presented. Every technical argument raised by the defense was met with probing inquiries, requiring immediate and thoughtful reconciliation with the particular circumstances outlined by Crockett, demanding a demonstration of how her framework could accommodate or address those technical nuances. As Bradford made his final, somewhat hesitant effort to justify his position, Judge Lyon turned his attention to both legal representatives, signaling that he had heard enough for the moment. In his calm and measured tone, the judge addressed the courtroom.
This has been among the most substantial, deeply analytical debates I have witnessed in over 20 years of service on this bench. His words carried a tone that was both composed and approachable, displaying genuine respect for the preparation demonstrated by both legal sides. He continued with sincere appreciation, commending their efforts, and then addressed Crockett specifically. Congresswoman Crockett, your argument has been nothing short of exceptional, not merely in clarity or presentation, but in the profound depth and precise understanding it reveals. He acknowledged her work as establishing a comprehensive framework for tackling the complex issues surrounding digital privacy breaches, an approach that deserved serious, thoughtful consideration from all involved in the case. The courtroom responded in subtle, almost imperceptible ways. Some of the spectators exchanged quiet, bewildered glances, while the journalists covering the hearing hurriedly typed notes and summaries, eager to capture and transmit what had transpired. The legal team representing the defendant absorbed the judge's praise with a mixture of surprise and contemplation, recognizing the unusual nature of such public acknowledgement from a sitting judge. As Judge Lyon finished gathering his papers and preparing to proceed, he stated clearly, "I will take this motion under advisement and issue a formal written opinion in due course." His words underscored the importance of the questions raised during the hearing, emphasizing that they touched upon critical issues, specifically how the legal system must evolve and adapt to technological advancements, issues that deserve far more than a cursory or hurried review. "This court is now adjourned," he announced, bringing the hearing to a close. As he left the courtroom, a wave of whispers and lively discussions broke out among the spectators. The gallery was alive with animated debates, with law students clustered in groups, dissecting every legal point that had been raised, while journalists scrambled to record memorable quotes and first impressions. At the same time, at the plaintiff's table, Crockett's co-counsel clasped her hand appreciatively, whispering, "Absolutely masterful." Crockett, feeling a rare sense of satisfaction, allowed herself a small, knowing smile. As the courtroom gradually emptied, the corridors of the federal courthouse pulsed with an electric atmosphere. Reporters hurriedly began transmitting their stories, sure that the hearing's impact would resonate beyond the courtroom walls. Sketches and summaries of what had happened spread rapidly through social media and legal communities. Many law students lingered in small groups, replaying and discussing each exchange, each argument, each subtle gesture, as if trying to fully grasp the significance of what they had just witnessed. Crockett collected her notes with deliberate calm, fully aware that the influence of her arguments was already beginning to ripple outward, far beyond the immediate confines of the courtroom. Her performance had been more than merely an oral argument. It was a statement, a firm declaration about the importance of law's adaptability, its relevance, and its ability to address the pressing questions of the modern digital age. By the time Crockett reached the steps outside the courthouse, a modest crowd of law students had gathered, waiting hesitantly but eager to engage. One of them called out, "Congresswoman Crockett, may we ask a few questions about your approach?" She paused, offered a warm smile, and nodded graciously. "Of course. The future of privacy law is in your hands. I'm happy to discuss it."
Cameras and smartphones immediately captured fragments of the conversation, which quickly circulated across social media platforms and legal forums. Within just a few hours, the legal community around the world began to analyze and debate every aspect of Crocketts' argument in detail. Law professors incorporated the transcript of the hearing into their class discussions, illustrating how classical principles rooted in common law could be elevated and applied to contemporary challenges posed by advancing technology. At leading universities like Harvard, Yale, and Stanford, students engaged in spirited debates over her framing of concrete harm, pondering its implications for future lawsuits and regulatory efforts aimed at protecting digital privacy rights. Legal analysts appearing on television screens carefully described her groundbreaking argument as nothing less than a paradigm shift, a rare and significant moment in the legal world that promised to profoundly alter the landscape of digital rights within the United States. They pointed out that her reasoning had the potential to challenge long-standing assumptions and redefine how courts approach issues related to technology, privacy, and consumer protections. Later that same day, within the quiet walls of her congressional office, Crocketts' dedicated staff assembled around her to provide a detailed briefing on the immediate reactions sparked by her argument. News outlets across the country had taken notice of a notable transformation observed in Judge Lyon. From initially dismissive and skeptical, the judge appeared to have shifted to a state of engaged attentiveness, clearly influenced by the compelling gravity of her legal reasoning. This shift was widely emphasized in media reports, which underscored how pivotal her insights were in reshaping perceptions of digital rights matters at the federal judicial level. At the same time, internal memos circulating among major law firms began to highlight the potential ramifications of Judge Lyon adopting Crocketts' innovative framework for understanding legal violations related to data. They warned that should the judge incorporate her approach, it could trigger unprecedented levels of legal scrutiny and review for major technology companies. Such developments might significantly alter the way these corporations handle consumer data, forcing them to reconsider their data collection and storage practices even beyond the legal courtroom and political arenas. Consumer advocacy groups, always vigilant in protecting citizens' rights, started mobilizing more actively, recognizing that her compelling argument could serve as a vital blueprint for enhancing and securing individual privacy rights in an increasingly digital world. The political implications of her argument quickly became more apparent as well. Analysts and political commentators began to speculate about Crocketts' rising national profile. They acknowledged that her deep expertise, coupled with her impressive courtroom performance, could catapult her into more influential roles, be it through appointment to higher judicial office or by taking on a leadership position within the legislative branch. Commentators praised her for possessing a rare combination: the practical experience of a seasoned courtroom practitioner, paired with a nuanced understanding of policy issues that influence the digital age. As word spread, social media channels buzzed with admiration, highlighting her ability to articulate complex legal doctrines with clarity, and her compelling moral stance, which underscored the importance of protecting individual rights in the face of rapid technological advancement. Within a matter of weeks, her legal influence materialized into concrete judicial action. Judge Lyon rendered a comprehensive, meticulously reasoned opinion spanning 87 pages, in which he denied a motion filed by a prominent technology giant seeking dismissal of the case. His detailed ruling extensively cited Crocketts' groundbreaking argument, particularly her framing of what constitutes concrete harm in cases involving unauthorized data collection. In his opinion, the judge explicitly stated that the unauthorized dissemination of personal information represented a real, tangible injury, one that merited legal recognition and could be addressed through judicial redress. He grounded this conclusion firmly in the principles of constitutional tradition and well-established common law, emphasizing that the invasion of personal privacy needed no further proof to be considered legally actionable. This decision was heralded by legal scholars and privacy advocates as a potentially transformative milestone, possibly the most significant privacy ruling seen since the landmark case of Carpenter versus the United States. The leadership within major technology corporations, sensing the profound potential impact of this judicial development, began internal discussions about their ongoing legal strategies and future compliance efforts. As news of the ruling spread, their stock prices experienced a noticeable decline, reflecting investor concern about increased legal exposure and the possible threat to their current business models. Simultaneously, other industry giants quietly launched internal reviews of their data practices, some enlisting external legal counsel to thoroughly assess their compliance with the evolving legal standards and to evaluate potential risks ahead. Privacy advocacy organizations, always vigilant in defending individual rights, publicly praised the ruling, viewing it as a vital step forward in fostering genuine enforcement of digital privacy protections. They recognized that this judicial decision could serve as a precedent, encouraging greater accountability and meaningful action to uphold citizens' rights in the digital realm. The influence of Judge Leyen's decision quickly extended beyond the immediate case. Within just 6 weeks, a federal judge in California explicitly cited his opinion when rejecting a similar motion to dismiss filed against another major technology company. Over the following months, additional district courts echoed this reasoning, referencing Crocketts' innovative framework and the landmark ruling in their own decisions. This wave of judicial support and consistency contributed to the gradual emergence of a broader consensus within the courts, reinforcing the significance and authority of the legal principles she had so skillfully articulated. The ripple effect demonstrated how her pioneering argument was gradually reshaping the legal landscape, setting new standards for digital privacy and consumer rights across the country. Law schools across the nation experienced a remarkable and unprecedented increase in student interest when it came to courses centered around privacy law. The surge was so significant that it marked a distinctive departure from previous trends, indicating a heightened awareness and concern among future legal professionals about issues related to personal privacy, data security, and digital rights. Simultaneously, various professional organizations, comprising legal associations, advocacy groups, and industry institutions, organized an array of seminars, conferences, and symposiums dedicated to examining the multifaceted implications of a landmark court ruling. These gatherings served as platforms for in-depth discussions on how legal, technological, and societal factors intersected in the rapidly evolving landscape of privacy rights in the digital age. Amid this heightened activity, Crockett, a prominent figure in the legal arena, found herself flooded with invitations to appear and speak at numerous influential events. Invitations poured in from academic institutions eager to hear her insights, from policy forums seeking her guidance on regulatory developments, and from conferences dedicated to civil liberties and technological advancement. Recognizing the importance of her voice in shaping public discourse, Crockett accepted these calls, often delivering compelling keynote addresses that underscored the critical importance of protecting individual privacy rights during an era characterized by exponential technological progress. Her speeches were marked by clarity, precision, and a depth of analysis reminiscent of her approach in courtroom litigation. She eloquently traced the historical roots of privacy protections, citing foundational precedents and constitutional principles that underscored the enduring nature of privacy as a constitutional right. At the same time, she addressed the immediate, practical implications of the recent court ruling for ordinary citizens, highlighting how new legal standards would influence data collection practices, consumer protections, and personal autonomy in daily life. Her ability to distill complex legal doctrines into accessible and actionable insights made her a sought-after voice in the ongoing debate surrounding digital privacy. Crockett's dual role, as both a legislator and a practicing attorney, enabled her to bridge the gap between theory and practice. She translated intricate legal concepts into concrete policy recommendations, advocating for legislative reforms that could strengthen existing protections or introduce new safeguards to better serve the digital environment. Her insights often influenced policymakers at various levels of government, prompting discussions on potential reforms that would complement judicial decisions. Within just 3 months after the courtroom hearing, public opinion surveys revealed a substantial increase in Americans' awareness of digital privacy issues. More citizens expressed concern about how their personal data was being collected, stored, and used by corporations and government entities, and many voiced a desire for stronger legal measures to safeguard their rights. This shift in public perception played a crucial role in shaping the legislative landscape. elected officials and policy advisors began to consider proposals for reform, recognizing that legal protections needed to evolve alongside technological advancements. The court case and Crockett's persuasive arguments in particular served as catalysts, igniting a national conversation that extended beyond the courtroom. It prompted broader discussions about privacy technologies, corporate accountability, and the ethical responsibilities of those handling sensitive data. The debate fostered a sense of urgency, encouraging lawmakers and industry leaders alike to prioritize privacy rights as a fundamental aspect of digital life. In the corporate realm, the case prompted one of the industry giants, known for its expansive data collection practices, to enter into settlement negotiations. Confronted with the prospect of extensive legal discovery and the possibility of trial under the new legal framework established by the court ruling, company executives recognized the risks of prolonged litigation and potential damages. Consequently, they agreed to a comprehensive settlement that aimed to address the claims of affected users and to restore public trust. The settlement package was extraordinary in both its scope and scale, amounting to a sum between $1,280 million and $8 billion in damages paid directly to those whose private information had been misused. Beyond financial restitution, the company agreed to implement rigorous new privacy protections, including measures to delete all previously collected user data, effectively rendering it inaccessible and unusable, and to undergo independent monitoring for a period of 5 years to ensure compliance with the stipulated safeguards. This oversight was designed to provide transparency and accountability, allowing an unbiased body to verify that the company adhered to the new standards over the long term. The agreement soon gained recognition as one of the largest and most comprehensive privacy settlements in history, setting a powerful precedent that resonated across the technology industry and beyond. Publicly announcing the settlement, Crockett stood alongside the lead plaintiffs, ordinary Americans whose personal information had been exploited without proper consent. During the press conference, she emphasized that this victory was about more than just monetary compensation. She underscored that the resolution reaffirmed a vital principle, that privacy remains a core right of individuals in the digital age, deserving of meaningful legal protections and enforcement. Her words reinforced the idea that safeguarding privacy was not only a legal obligation, but also an ethical imperative that required continuous vigilance and collective effort. The outcome was heralded as a significant triumph, not only for the individuals whose data had been compromised, but also for the broader principles of justice and integrity within the legal system. It demonstrated society's firm commitment to holding powerful corporations accountable for their actions and ensuring that technological innovation does not come at the expense of individual rights. Media outlets extensively covered her involvement, portraying her as a central figure in the achievement of this landmark victory. Her role solidified her reputation as a formidable advocate for civil liberties and digital rights, further elevating her standing within both legal and public spheres. The implications of this case for the legal profession were profound and far-reaching. Law firms and legal practitioners recognized the necessity of re-evaluating their strategies to adapt to the emerging landscape of privacy law. Many began proactively assessing privacy risks associated with their clients' activities, developing practices aligned with the evolving judicial interpretations and regulatory standards. This shift in approach was driven by the understanding that being reactive was no longer sufficient in safeguarding clients' interests. Instead, a proactive stance was essential. Legal scholars and academics, meanwhile, continued to study Crockett's arguments, viewing her legal advocacy as a model of effective litigation. Her ability to combine detailed historical knowledge, a deep understanding of constitutional principles, and practical evidence set a new standard for legal advocacy in privacy cases. Her speeches and written works became reference points for future cases, illustrating how nuanced legal reasoning could influence both judicial decisions and public policy. In essence, her influence extended beyond the courtroom, shaping the way privacy rights were understood, interpreted, and implemented in an era of rapid technological change. Her approach to the case was widely regarded as an exemplary demonstration of both intellectual mastery and persuasive eloquence. It served as a vivid illustration of how one could seamlessly connect meticulous legal reasoning with broader moral considerations and societal responsibilities. Through her words and arguments, she not only showcased her deep understanding of complex legal principles, but also bridged the gap between technical legal doctrines and the moral imperatives that underpin justice in the digital age. Her presentation became a benchmark for clarity and conviction, inspiring many legal professionals and students alike. Exactly 1 year after that pivotal hearing, the tangible repercussions of her efforts became increasingly apparent throughout the entire technology sector. Numerous companies, recognizing the significance of her legal stance, undertook comprehensive updates of their privacy policies. They clarified how they obtained user consent and introduced more transparent mechanisms for data collection and processing. In addition, these enterprises adopted new, more rigorous standards for handling personal data to align with principles articulated during the case. Industry associations, inspired by Crocketts' compelling argument, began to establish detailed guidelines for integrating privacy by design into their development processes, emphasizing that privacy considerations should be embedded from the inception of any technological project. This legal milestone also fostered a heightened awareness among consumers, who became more assertive and informed about the use of their personal information. Empowered by the legal precedent that explicitly recognized individual rights, they started to question and scrutinize corporate data practices more critically. The case ignited a wave of consciousness about digital privacy, encouraging individuals to stand up for their rights and demanding greater transparency from service providers. Within academic circles, the importance of the case was equally profound. It quickly became a foundational reference point for teaching privacy law, inspiring countless seminars, textbooks, and scholarly debates. Harvard Law Review dedicated an entire special issue to analyzing the implications of the Crockett framework, particularly exploring how its principles could be applied to emerging technologies such as social media platforms and artificial intelligence systems. Meanwhile, Georgetown University established a prestigious annual lecture series in her honor, focusing on the crucial intersection of technology, civil liberties, and legal regulation, a testament to her influence on future generations of legal thinkers. Prominent legal scholars lauded the case as a watershed moment in contemporary jurisprudence. They noted that Crockett's arguments had elevated public understanding of privacy rights far beyond the technical jargon often associated with digital data. Instead, her reasoning helped frame privacy as a fundamental human right, the core of civil liberties in a rapidly evolving technological environment. Over time, her contributions solidified her position as a visionary who reshaped the narrative around digital rights and personal data protection. 2 years after the hearing, as Crockett prepared to run for her 4th term in Congress, an unexpected call from the White House disrupted her routine. The president was contemplating nominating her to serve on the United States Court of Appeals for the District of Columbia Circuit, a prestigious bench that, had the recent settlement not taken place, would have heard appeals from major technology companies. Crockett reflected carefully on this potential appointment, recognizing the gravity of such a step. Throughout her career, she had been driven by a steadfast dedication to ensuring that the law served principles of justice and fairness for ordinary citizens. Whether operating within the halls of Congress, standing in courtrooms, or potentially serving on the judicial bench, her steadfast focus was always on promoting and safeguarding fundamental rights amid the complexities of a transforming technological landscape. The legacy of her confrontation with the tech giant extended far beyond the immediate legal victory. It fundamentally altered public perceptions of digital privacy, shifting the societal narrative toward valuing personal data security as a critical component of individual rights. Her case set influential legal precedents that continue to shape data protection laws and organizational policies to this day. Moreover, her standing and perseverance proved to be an inspiration for an entire generation of young attorneys and activists, many of whom now see privacy advocacy as an essential front in the ongoing civil rights movement. Her efforts laid the groundwork for a national consciousness that personal information could not be exploited without meaningful recourse, affirming that certain rights remain inviolable, even as technology advances at unprecedented speeds. Crockett's compelling argument became a foundational reference in legal education, policy debates, and public awareness campaigns across the country. Law students studied the nuanced reasoning behind her case, extracting lessons about how to balance innovation with fundamental rights. Legislators looked to her insights when drafting new privacy laws, while privacy advocates cited her framework as a gold standard for best practices. The ripples emanating from her courtroom performance were tangible and far-reaching, influencing lawmaking, corporate policies, and societal expectations about digital conduct. Even as ongoing legal proceedings related to the technology company continued through auxiliary filings, compliance evaluations, and other legal maneuvers, Crocketts' extraordinary performance in front of Judge Leyen remained a defining moment in her career and in the broader fight for digital rights. Her contribution not only shaped the immediate legal landscape, but also planted seeds for a future where privacy and civil liberties enduringly occupy a central place in the democratic discourse. The case served as a powerful demonstration of how meticulous preparation, a deep understanding of historical legal principles, and sharply crafted advocacy can come together to create a profound influence on the legal landscape. By carefully situating the modern concerns surrounding privacy within the framework of centuries-old legal traditions, she managed to weave a seamless connection between the wisdom of past jurists and the complex challenges presented by today's digital age. This approach not only lent credibility and weight to her arguments, but also provided a comprehensive blueprint for courts, policymakers, and ordinary citizens alike, illustrating effective ways to confront and address the intricacies of privacy in a society increasingly dominated by technology and data. As Crockett moved through the corridors of Congress, amidst the echoes of deliberations and the weight of history, she understood that her efforts extended far beyond her roles of a legal representative and an advocate. Her work had evolved into a much larger statement, a testament to the unwavering relevance of foundational legal principles, the remarkable adaptability of the justice system to new realities, and the moral obligation to shield individual rights from the ever-changing threats posed by technological progress. The entire process, from the initial hearing to the final ruling and subsequent settlement, marked a significant milestone in the ongoing worldwide effort to find a delicate balance. This balance aims to foster technological innovation while simultaneously upholding the inviolability of personal privacy and human dignity, especially in an era characterized by unprecedented access to data and digital footprints. For the general public, the case shed illuminating light on the actual implications of privacy concerns in everyday life. Ordinary citizens, who perhaps once viewed privacy as an abstract or distant concept, began to realize that ideas once confined to legal textbooks had now become tangible, enforceable rights rooted in both legal statutes and historical precedent. They gained a clearer understanding that consent, transparency, and accountability were not merely lofty ideals or vague notions, but were concrete rights that could be upheld and litigated in courts. Crockett's staunch advocacy transformed the conversation surrounding privacy from a theoretical legal discourse into a practical, accessible principle that resonated deeply within society. Her work implied that justice was not a static concept, but capable of evolving in tandem with technological advances, ensuring that the rule of law remained relevant and effective. By the time the second year following her pivotal case concluded, the principles and framework she introduced had become firmly anchored in the collective consciousness of American law. Courts across the country, corporations handling vast quantities of data, educators preparing the next generation of legal minds, and the public at large recognized the enduring significance of her contributions. What initially started as a courtroom battle of high stakes expanded into a broader societal movement, a movement aimed at reshaping the very landscape of digital privacy rights. This movement sought to redefine standards and set new benchmarks for safeguarding fundamental human rights in a society driven increasingly by advanced technology and constant data exchange. Her arguments, meticulously preserved within court transcripts, incorporated into case law, and analyzed extensively in academic circles, would serve as a guiding light for future advocates and jurists. They would confront the ongoing challenges posed by the digital era, ensuring that privacy remained not just an aspirational goal, but an enforceable, protected right. Crockett's work laid the groundwork for a future where human dignity, autonomy, and personal privacy could be preserved and respected, regardless of the rapid pace of technological development that continued to transform society at every level. Her influence persisted as a testament to the power of well-founded legal reasoning and persistent advocacy in shaping a fairer, more just digital environment for generations to come.